Justice Ditkoff. We're the panel that's going to be hearing your case today. Mr. Miller, you will be arguing first, and you have 15 minutes to present your arguments to us. After that, we'll hear from Attorney Kennedy. There is no rebuttal. What I mean by that is after Attorney Kennedy finishes her argument, that you do not have any opportunity to respond. So you need to tell us everything you want to tell us during your first 15 minutes. I want you to know that we've read everything you've submitted to us, and so we're very familiar with your case, and you can get right into your important points. I'm also going to say to you that if you lean back a little bit, we can see your entire face. There, right at that point right now, we can see you. Can you see us as well on the screen?
I can see you, and I don't identify 1, 2. The sign myself, I see myself for the first time.
Okay.
I got who's here position wise, and I'm gonna sit back and I'm gonna listen and I'm gonna respond.
Okay, well, at this point right now, it's your turn to talk to us, and it's your turn to tell us about your case. You're going to see in the corner a clock. It's going to read starting at 15 minutes, and it's going to go downwards. You have a full 15 minutes to tell us about your case and to answer our questions, okay? And we're going to start right now.
Good morning.
Good morning.
My name is David Theodore Miller. I'm currently at MCI Shirley Medium. Please be advised that last night's events in my life were not comfortable. I was on video surveillance in a cell somewhere for a specific reason that has nothing to do with today's matters. My intentions today is to relay first my current situation as it pertains to the case and what I know of the case. I presented myself pro se today upon signature on every missive that reached this panel. Technically, I did not type and write every missive submitted. Some of them I'm apprised of because of the help of a certain individual at this time. As far as my pro status state, my pro status situation is in Massachusetts under the laws and regulations of the chapters applicable to that right there, what I just said, the honor and your honor and your honor. And I think clerk. So at this point, I don't really want to argue the actual item of the chain, right? That's at argument because the defendant, Ms. Kennedy, wherever she's at, is negligent.
Are you referring to the delay in answering
actual item? The situation in front of the courts is that the chain is in my son's possession at this point, but a legal hold was filed at some point. My argument is that my ring cost $1,000 and I paid for it. I got 7 diamonds in it. It's silver. It's size 14.5. And I told the jeweler where to put the stones, you understand, pertaining to my wedding ring. And it's on my fingers, on my books. Secondly, the chain, I had it since 2011 when my father passed away. Month and day specifically, I don't know. My argument is that I put in a slip to Greg McCann, part of my tone and language due to COVID-19 and possibly positive. Pertaining to the chain, my son has it currently. The defendant received my litigation hold as it pertains to property at Shirley. But so the physicality of the chain is in my son's hand. So I don't care about the chain personally. The matter is I submitted to Greg McCann when he took it. I paid over $1,000 to reconstruct the chain, the size of the chain, excuse me. What's my time for argument?
You still have 12 minutes, sir.
Okay, so I paid a certain price to resize the original chain to Greg McCann's liking. And then he told me, listen, if the religious board wants to allow you to have it, you can have it. Send it to the religious board. Greg McCann said that to David T. Miller on what date I'll research. What's submitted, if it's there, I'm not sure, in the missives in front of the court. But verbally, that's my word to the situation of the chain.
Mr. Miller, if I can ask a clarifying question, are you saying your interest now is limited?
Sir, is my time still running?
Yes, it is,
that's,
sir.
That's what happens during this time. We ask you questions.
Let me explain. The litigation hold was filed for the chain. It was in property since 2015, the day it was taken. I never tested. That I gave it to him after it was on my books already. That's not the law in Massachusetts. The law is, okay, so the lieutenant said, let me see your chain. I said, here. He said, I need to grab that. I said, why? It's mine. Possession is 9/10 of the law in Massachusetts, under my understanding. And I've had it, and I had permission to ascertain it.
Sir, I'm going to interrupt you, sir. I'm going to interrupt you for a moment because Justice Milkey had a question for you. And this is our opportunity also to ask questions of you to clarify things in the record.
All right,
so just wait one moment, let him answer, let him pose his question and you can answer it, okay?
Yeah.
My question, sir, is, are you now essentially abandoning the argument about the chain and limiting the appeal to be about the pendant itself?
The pendant I would like to have personally because of my possession of the law and how I lost my pendant physically in the day, and Daryl Olger is the lieutenant, and he's very vicious with his personality. And I personally know him from 2001 when he was my block officer on my first state sentence. So up until now, he took my chain, and his reputation is that he takes everybody's chain if he doesn't like it. His words to me, Your Honor, was if it was a Jesus head with the thing that they sell or cross, I could let it slide. But that is not religious in the size matter. And I specified the sizes to meet the requirements, and it cost me $1,250. And I want be reimbursed for that in cash, because Greg McCann told me, make it to your size and I'll let you get it when it gets here. And I said, I'm gonna send it to you in your name and property. When it gets here, you tell me. I went to happy hour. He said, oh, you can't have it. I said, that's not what you said, Greg. He said, Daryl said the religious board doesn't approve it. It's a verse from the Quran, the Holy Quran, and it has diamonds around it. But the value in Massachusetts DOC is it's only $50. You can't have it. But I have this ring and I paid $1,000 for it. It's right there.
Sir, do you dispute at all the value of the medallion and the change?
Not at all, but consent-wise, if I lose this ring, I get $50 from DOC. But I still have my ring today, $1,000. And Joan Kennedy and the defendants say I can't have my pendant or my chain that's worth a little bit more. But the sentimental value to me and what that chain means is life is $1 million. But my son has a chain.
Wait, hold on 1 second, sir, because I see that Justice Ditkoff has a question for you.
Yes.
Wondering is, if you got an order that said you got your pendant back and you could possess it in the prison, would you be satisfied? Is that the thing you want, or are there other things you want?
Yes, Your Honor. Yes, tremendously. But it would have to be that same exact chain. But the problem is my son has possession of it. I gave it to him on his birthday, September 30th, and it's his by my word, that actual item. That's why I said the defendant is in violation of the first court's legal hold order.
So let me clarify. Let me ask the same question, just a little bit differently, given your answer, if I may. Yes. If you were to procure another chain, and maybe even a chain through an appropriate vendor, and you had that chain with the medallion that's the subject of this controversy, would that satisfy you?
My thing is that any vendor appropriate by DOC, what Daryl Olger says, sells crap that would break on my neck if I turn left or right. Excuse my language to the courts, please. Sleep deprivation is up. So I'm trying to convey myself with my time limits. So I would accept either my refund for my resizing of the original chain, and I don't have a chain for the rest of my life sentence. I'm cool if that's what it is, and the courts, please. Or I would like that same exact chain to be a prize constructed and allowed for me to ascertain, because the actual chain that we're talking about is my son's as of now.
Mhm.
And the only problem legality wise is the fact that to construct the exact chain is going to cost about, appraisal wise, $3,000 to my knowledge about jewelry, because this ring is $1,000, and I know the carats, I know the construction, so it's gonna maybe, hold on, 36 carats, the piece construction, the chain, so that legally you guys could say yeah, but DOC wise law, that would be wrong, because I think the value has to be $50.
Correct.
Yeah, but
That's
sir,
For me to, so this ring.
Hold on, sir. I'm sorry. Justice Milkey has a question.
I'm just a little confused about why you think the chain would be $3,000, given the chain is simply made of silver.
Hold on.
And aren't the diamonds in the pendant fake diamonds, as it says on the?
I would never wear fake diamonds, Your Honor. So the diamonds is 3.6 carats in totality. I have pictures of the actual diamonds in my cell, but I don't have I could get the receipt possibly for the chain and the medallion. That's a fact. So for as far as my appraisal was, so 3.6 carats, I can count the stones and tell you the cuts on them. I don't know how much time I got, 5 minutes?
That's correct.
So I know the appraisal for that from a jewelry store that I brought the original diamonds from, right?
Okay. Let me ask you this. I'm going to ask you this, if I may, sir. Did you ever discuss, or did you ever consider other alternatives in terms of wearing the medallion in a different way, or storing it someplace different? There was some discussion in the papers about whether or not at another time other people have worn it on something similar underneath their shirt or something like that.
At this time, I would like the courts, the justices, to consider what I can have pertain to the ayat, the verse, and the pendant and the chain. If I can't have something that I'm satisfied with, I decline. But my main concern is my original reimbursement for the reconstruction of the first original chain, the specs, the sizes. If the courts need the information about the new one, I could provide it for them. I can get pictures of the stones. And if we want to talk about the originality of the chain itself, I can do that as well. But time-wise, in my situation today, possibly being COVID-19 positive, I'm limited.
Okay. Is there anything else that you want to tell us about your the case that you filed before your time is up?
So the case that I filed, as it pertains to the originality of the piece and the chain dependent, the verse is my mother's favorite verse from the Quran. And as a child, she would tell me to recite it before I move or whatever the case may be. So I memorized the verse. And her death date and the diamonds, everything about that pendant is sentimental as it pertains to the capacity of my DNA family. I have a deceased mother, deceased father, I have a son, I'm in prison. And I'm trying to start a movement called FNT currently pertaining to incarceration in front of the courts. At this point in time, I want to say that I really don't care about the chain. My mental concern about this whole situation as it pertains to the day I lost the chain and now, and my son owning it, is my cost for the construction of the chain originally, which I didn't file. I only filed the sentiments of the chain and how I ascertained it. In front of the courts, I would like a chain exactly like the one my son has. If I could have it, DOC says I can't religiously. I'm not sure what's filed. But as far as I'm concerned today, I spent $1,250 to reconstruct the one that my son has, which is the chain of question, which the defendant is in negligence right now because he owns it. And I decided between 2015 and February, when I lost it, till now, the litigation's length, frustration-wise, COVID-19, his birthday, my finances, everything in life realistically about a human man and his relationship to his son and my incarceration currently, I gave it to him. But he was the lieutenant who sent it wasn't supposed to do that according to the court, not this court, but the court below. But I don't have a problem with that lieutenant, and I wouldn't like to see him penalized as it pertains to the capacity of his job in front of the court's panel, please. Lastly, when I have a minute and 12 seconds, emotionally wise pertaining to me not having that chain and what I spent for physically to reconstruct it after Greg McCann told me to do so. When I see Greg McCann, I'm gonna say, hey man, Daryl Olger didn't allow me. Then you told me that, because his words in the unit when I spoke to him in C2, at the end of a shakedown or a situation where the block was cleared in the middle of the tables of the first two, he told me, I don't have a problem with you having the chain, David. The size and the value is too much. I said, this is what it means to me. I had it since I was in Susan Baranowski since 06 to 15 or 12. I went to Old Colony with the chain and I had it. Wasn't a problem security-wise or what have you. DOC's argument is influence and value and my effect on others as far as my personal capacity in Massachusetts right now. And what I'm doing, I'm talking about Fathers Not There, a movement, nonprofit organization.
Could you tell that? Could you give me the initial? It's Fathers Not
FNT.
FNT. And what does T stand for again?
Excuse me?
T, the T.
Fathers Not There.
Okay, not there. Okay, thank you.
Acronym.
Sir, your time is up.
Ladies and gentlemen, thank you for the courts, and be safe, social distance, don't catch COVID.
No, thank you very much, sir. You can stay now on and listen to the argument of Attorney Kennedy, okay? So just, but you're not allowed to say anything, you're not allowed to respond or anything. So just listen. Thank you very much. Attorney Kennedy.
Joan Kennedy, on behalf of the named defendants, who are Raymond Marchilli, the former superintendent of MCI Shirley, Daryl Oja, lieutenant, property officer at the time in question, and the third person is Monica Forrest, who was the institutional grievance officer at the time in question. May it please the court, I would request that the lower court's judgment for defendants concerning plaintiff's First Amendment right to possess what was a contraband religious medallion and chain be affirmed by the court.
Counsel, could we start with the issue of which is the operative complaint? Isn't Mr. Miller correct that he did not need court approval to amend the complaint?
He did not need court approval to amend the complaint, and the amended complaint was never accepted technically by the court. In reviewing the folder.
Why does it have to be accepted by the court?
The court had at oral argument when the parties were before the court on cross motions for summary judgment. The plaintiff in this case, Mr. Miller referenced the amended complaint, and I was taking that into consideration. I mean, his initial complaint is rather Spartan, but I knew he was talking about First Amendment rights. I knew he was talking about RLUIPA because this was a religious medallion and chain, and he was seeking essentially an inmate religious accommodation from the agency.
So why shouldn't we go with the amended complaint?
You can go with the amended complaint if the court chooses to do so. It's certainly part of the lower court's record. And again, I believe the justice in this case, Justice Barry Smith, had also looked at the amended complaint because it was something that Mr. Miller in oral argument had referenced. So although there was no motion for leave to file and the court didn't necessarily give its imprimatur, he is a pro se plaintiff, and the court and me, all of us, would give him leeway with regard to that. That would only be appropriate.
Okay, if you, as you do in your brief, consider this a 30A appeal of the denial of a grievance, how would the filing of the Hopkins affidavit be proper, where 30As are based on record review?
It's record review, but in this case, there's the inmate grievance policy has actually a carve out in the sense that if an inmate is seeking a religious accommodation, and in this case, this is a religious accommodation with regard to the medallion and chain, there's this particular venue that he needs to go through, which is the Religious Services Review Committee. That was actually acknowledged by, if you look at the amended complaint, if we're going to use this at the operative complaint, and I accept that premise from the court. the amended complaint, he references a prior grievance that was 79305. And in his amended complaint, I believe that's Exhibit A to his amended complaint. And in that, Monica Forrest tells him that, this needs to go as a religious request with regard to the medallion and chain because it is non-compliant with the inmate property policy. And again, in the grievance policy, there's a few different carve-outs.
No, I understand that in terms of 103 CMR 4471-0.08. But if this is in fact a proper case under RLU IPA, then how is the motion you filed a motion for judgment on the pleadings as opposed to a motion for summary judgment?
In order to allow the court to review both administrative records, because initially he files the grievance package is completed by Monica Forrest. That's at the institutional level. The Religious Services Review Committee reviews all inmate requests for religious accommodations. And in this case, because RLUIPA acts in essence in equity, and the inmate, Mr. Miller's request here repeatedly is to be able to retain this particular religious medallion and chain. The department's position is that this is contraband, and he has conceded in his presentation that it's far in excess of $50. And so we wanted to exhaust his administrative remedies for him. And he was directed in the prior grievance 79305, which is attached to his amended complaint, to go through the Religious Services Review Committee process.
But you never, in fact, raised exhaustion as an affirmative defense. In fact, you never answered the amended complaint, correct?
I did not answer the amended complaint. I basically filed with the court 2 administrative records, an institutional grievance record and also the Religious Services Review Committee record.
And how is that proper where an RLU IPA is an affirmative judicial action, not record review?
Because the department is obligated, and the department's been on notice that our process is appropriate under the Rashid case and the Ahmad case. We basically set up the whole Religious Services Review Committee to do the balancing that's required. Certainly, Mr. Miller's made an argument that this is part of his faith process, and we are substantially burdening him by not allowing him to have this particular religious medallion and chain.
And do you contest that it is substantially burdening him?
Yes, I have. Oh, yes.
So where in the summary judgment filings is that issue addressed?
It's addressed in the affidavit of Jaylene Hopkins and the decision by then Commissioner Thomas Turco that this religious medallion and chain cannot remain in the correctional facility. It is what we did as an alternative, which is what RLUIPA requires. There's supposed to be some play in the joints, as the United States Supreme Court said in Carter v. Wilkinson, with regard to institutional security. We have a compelling security concern with regard to Mr. Miller's retention of this religious medallion and chain while he's in general population. Mr. Miller has indicated that he is serving a life sentence without the possibility of parole. And our concern is that nothing has transpired at this juncture, but something could in the future. If the court looks at the Supreme Judicial Court case in Rashid, the inmate in question was serving a life sentence without the possibility of parole. He was in a single cell at Cedar Junction back when it was a maximum security facility. Again, just like Mr. Miller, a devout Muslim, plaintiff inmate, and he had a variety of religious items in his cell that he had acquired over the years through probably the allowance of a superintendent. Those items were deemed nonetheless contraband. It was a prayer rug, it was an ablution pan, it was an excessive amount of prayer oils, a variety of objects. And the Supreme Judicial Court said those can be deemed contraband. Our property policy also allows for that. At 4103.
But isn't the threshold issue whether it substantially impedes his religious practices? And maybe I'm missing it, but I don't see anywhere in Judge Barry Smith's opinion where he addresses that issue.
Judge Barry Smith's opinion is short, and it kind of dovetails. It references the motion for judgment on the pleadings and opposition and cross motion for judgment on the pleadings that I filed on behalf of the defendants. But actually, in my opposition and cross motion, I referenced Spratt versus the Department of Rhode Island. And in that case, the First Circuit Court of Appeals talked about what is a compelling security issue, and that the fact
No, but counsel, understanding now that, as I believe you have acknowledged explicitly or implicitly, this was more properly a motion for summary judgment, we would have to find that there's not a dispute as to material fact about whether or not there's a substantial impact on Mr. Miller's right to practice his religion. That issue does not appear to be addressed virtually anywhere in the summary judgment filings, papers, and decision. Tell me why I'm wrong.
I would point the court to the affidavit of Jaylene Hopkins and the whole religious services review.
I read it about an hour ago.
Again.
Basically, under the Religious Services Review Committee process and the RLUIPA statute, we as correctional officials are supposed to engage in a balancing situation here. We have a compelling security concern, and my commissioner did at the time, with regard to this religious medallion and chain being in his possession. And in that case, when you have a RLUIPA situation like this, where there is a compelling security issue with regard to possession of this particular medallion and chain, the balancing that we offer as an alternative for him is that he can have a religious medallion and chain that conforms with his Muslim beliefs. It just has to meet the property dictates of being $50 or unders. That's consistent with how every other inmate is treated with regard to religious medallion and chains.
One second. I believe Justice Ditkoff has a question, but Justice Ditkoff, we don't hear your voice.
Oh, really?
Now we do. Now we do. Yes. Now we do. Yes.
Get a little closer. Counselor, can you tell me where in this affidavit is it explained why this is a security risk? It talks about how the policy works, but I didn't see that.
The security constraints are not explained explicitly in Jaylene's affidavit. However, it's referenced in the decision of the Religious Services Review Committee. They looked at this religious medallion and chain. The photographs were reviewed by the committee. They see the object as having a lot of diamonds in it. It's been conceded by Mr. Miller that it may be 36 diamonds. Certainly, I think at this point we are all comfortable with the fact that this object, this religious medallion and chain, whether it's the chain or certainly the medallion, is well in excess of the $50 limit that the department has for religious medallion and chains. And also attached to Jaylene's affidavit is a photograph of what is currently most typically allowed for religious medallion and chains. If an inmate has particularized religious practice where the medallion and chain for, say, a Wiccan inmate is not suitable.
Counselor, I'm now looking at page 69 of your record appendix, your supplemental appendix, which I think is the Religious Services Review Committee's decision on Mr. Miller. And I'd like you to tell me, maybe I'm looking at the wrong thing, but if that's the right thing to be looking at, could you tell me where that explains why it is a security problem for him to have this medallion? And I could be looking at the wrong thing, so if I am, just tell me and I'll look the right thing. But
this talks about that we don't permit it, that it's a problem.
But to say we don't permit it doesn't explain to me why it's a security risk. To say
Well,
I don't permit it does not. That is exactly what the RLUIPA is about, getting rid of that sort of conclusory.
Directing the court's attention to page 71 of the supplemental appendix, the decision of who was then the director of program services and reentry, Christopher Mitchell, who chaired the Religious Services Review Committee at the time in question. He talks about that the committee had a problem with regard to it because it was confiscated from him. It had come in from a jewelry store. The committee reviewed it and they agreed that the pendant set was contraband because of its size, dimensions, and value, all of which raised compelling security concerns in a prison environment where it could be stolen for the inmates or inmates may barter with him to be able to wear it for status purposes or during family visits. And then it recites the inmate property policy about the value of it. The inmate states there had been dialogue at the institutional level as to whether another religious medallion and chain that it comports with his faith would be acceptable to him. Mr. Miller, said that no,
Do you think you
the
can
first
get
month,
summary, do you think you can get summary judgment based on an unsworn letter written by the Director of Reentry and Program Services Division? Is that enough to get summary
these are
judgment?
business records in the regular course of business with regard to the way the Religious Services Review Committee functions. That is the function of Jaylene's affidavit, is to give life to these and also to keep me from a hearsay, situation or issue in regards to.
Counsel, isn't it uncontested that officials at other institutions allowed Mr. Miller to have this? And I understand your argument that there's no estoppel here, and frankly, I agree with it. But as a separate matter, isn't that some evidence of what the least restrictive alternative might be in the analysis that is required under Holt v. Hobbs if there's a substantial burden here?
No, Holt v. Hobbs, I think, was different, Your Honor, with regard to the fact that it was sort of an all or nothing proposition. The inmate in question wanted to grow what Mass DOC correctional officials would construe as a modest beard. And 38 or 41 other prisons did not agree with the Arkansas Department of Correction with regard to the size of the beard for for the inmate in question there. With regard to this is a religious medallion and chain. The department's regulations are very clear with regard to that. Equity was done here in the sense that it's also been kept in abeyance.
Doesn't Holt v. Hobbs essentially say that if there's a substantial burden on a religious practice, you can't hide behind the regulations and say that's enough?
No, because again, the department went through a second, a third, and a fourth step. Under Spratt v. Rhode Island DOC, the first two burdens of the inmates, he is certainly, we'll all agree on that, has met his burden, that he believes his faith has been substantially impaired because he cannot have this particular religious medallion and chain. That being said, the third question is the compelling security concerns of prison officials. That's articulated here by my commissioner. And then the least restrictive means is that he can have a different medallion and chain, and I'm out of time.
You're out of time, but I have one last question from me. In his brief, he has suggested a couple of alternatives, including, for example, wearing the medallion under a shirt or even having it confined to his cell. Why don't those satisfy your security concerns?
Because at some point that religious medallion and chain, the thickness of the chain alone and the medallion itself may slip out when he's going to the shower, when he's going to the gym, during visits, during a visit to the health services unit. There's no guarantee that at some point that won't be inadvertently seen by another inmate and cause an issue of jealousy that causes a security concern. I do have a plaintiff here who is serving a life sentence without the possibility of parole. I would strongly suggest to the court that the reasonable alternative here is that he order a religious medallion and chain that's Muslim, that meets the parameters of his faith, that also comports with the DOC's property regulations. And I would point the court, if I can, in closing, to the Rashid case and the Ahmad case, with both stand for that proposition.
One last question. I presume that the authorized vendor does sell something similar under $50?
Yeah,
the cost?
Always the issue here is to keep it under $50 to avoid inmate jealousy type of issues and things
Right.
like that.
So that's the cost of the items that are available through the vendor is under $50.
Yes, Your Honor, that's pursuant to the inmate property regulations.
Okay. All right, well, your time is up. I'm just going to check with the panel to see if anyone has any more questions. I say they do not. I want to thank you both very much for your arguments. No, sir, I'm sorry, you can't talk at this point, and you're on mute anyway. But I want to say to both of you, thank you very much for your arguments. We'll take them under advisement and again answer to you as soon as we possibly can. And in the meantime, to both of you, on behalf of the panel, we do hope that you stay safe and social distance and do all the things that we need to do to get through this pandemic. So thank you very much. And we appreciate your arguments.
We're live.
Thank you very much. Okay, so that's what happens when one tries to take over someone else's role. I'm now going to call the first case, Commonwealth versus Jonathan DaSilva, 2020-0598. I'm Justice Vuono. I'm joined today on the panel by Justice Milkey and Justice Ditkoff. We've had some technical difficulties today. We thank you for your patience, and let's hope that we've had enough of that for the remainder of the day. Attorney Owen, you go first. As you know, you have 15 minutes for your argument. And Attorney Armstrong, you also 15 minutes. And Attorney Owen, just remind you there is no rebuttal. So please go ahead and begin your argument.
Thank you so much, Catherine Oren for Jonathan DaSilva. If I can have roughly 3 minutes, please. Evidence deficiency here is that simply laid plain. Facts proved traffic stop flight through streets known for gun crimes, where police later found 2 guns. And Jonathan DaSilva trapped as a passenger, then accused of having carried those past street guns. The SJC in Jefferson mandates required not guilty findings. That's the Commonwealth's best case. So the SJC deemed evidence sufficiency there a close issue. And even that close issue spotlights material deficiencies here that foreclosed proof beyond reasonable doubt that DaSilva had constructively possessed past street guns.
So, Attorney, can I interrupt you just for a moment? Could you tell us how is it that your case differs from the facts that the SJC reviewed in Commonwealth versus Jefferson?
Sure. Well, in Jefferson, the evidence proved midnight streets devoid of alternative gun sources. No cars, no pedestrians. Here, the guns could have come from anywhere. It was late afternoon. The streets flowed with traffic. No evidence suggested streets deserted of pedestrians. So that's a big distinction. Also, the guns here could have come from any resident, visitor, or person passing 28 High Street. Police had no idea how many people lived there, even who had been by there.
Counselor,
No statement by...
One moment, Counselor.
Counselor, doesn't that distinction cut both ways? If there's a lot of people around, then it seems almost impossible that a gun could be there for any long period of time. At least at midnight, a gun could be there for an hour before someone notices it. But with moderate traffic, people around, it would have been reported immediately if it hadn't just been thrown out of a car.
Sure, and the thing is, it could have been there for 5 minutes or longer, 10 minutes. It's not that it would be instantaneously discovered. And the logic in Jefferson makes it clear. In there was a statement from a resident that stressed she had never seen guns at her home or on streets around it. And here, we had no statement by any such person. That part of Dorchester was known for gun crime, and there was no idea. Police literally didn't know even how many people lived at that address, much less who had been by there. Additionally, Jefferson hinged on a gun broken in pieces, which was consistent with sudden pavement impact after being thrown from a passing car. And here the guns bore merely minor scratches, consistent with any number of causes over time. Another big distinction. Percival feigned no stop to trick police. He made no statements about crime involvement. He didn't scoff derisively at stop for a mere traffic offense. Here it didn't even show, the evidence didn't even show that Percival was licensed or that the car was registered. Good reasons why someone would flee a traffic stop, risking arrest and impoundment. And that inverts every fact in Jefferson, suggesting flight born of criminal guilt. And finally, police saw DaSilva do nothing, both during and after Percival's traffic stop flight. No attempted escape, evasiveness, deceit, or furtive gesture signaled anything like consciousness of guilt, or even so much as stress. Nor did DaSilva say anything, much less suggest crime involvement. And the SJC stressed that in Jefferson, evidence sufficiency was a close issue. Constructive possession proof here stands distinct from Jefferson in every material respect. And Jefferson is the Commonwealth's best case. That very authority serially spotlights deficient evidence here. It mandates reversal and entry of judgment for Jonathan DaSilva. It's not every day. Both sides of the V are pointing to the same exact case as their best authority. And here the SJC mandates required not guilty findings.
Okay. You still have, I don't know if you can see your timer, Attorney Oren, but you still have a little over 10 minutes for your argument. Is there anything else you want to bring to our attention?
No, as I state, it is such a simple thing to lay out the material deficiencies here that materially depart from Jefferson. And if in Jefferson it was such a close issue and that the SJC stressed it, the evidence here fails as a matter of law. And it's that simple.
Counsel, Judge Milkey, I take it that part of your argument is, as between the two defendants, there's insufficient evidence that your client possessed the gun.
Well, I'm saying there's no reason to think that gun came out of that car at all.
No, I understand that, but
right.
Are you arguing this point as well? That even if the gun came out of the car, there's insufficient evidence that your client was the one who possessed it?
Well, I just don't see any evidence that on Jefferson's own logic, the SJC's own logic, I don't see any way anyone could reasonably infer beyond reasonable doubt the car came out of the gun came out of that car. And I'm not making any other argument. There are no grounds on which to make it. There's no reason to think anyone in that car.
Isn't it fair to say, and this is Justice Vuono, isn't it fair to say that where these two guns were located at 28 High Street corresponds to when the car driven by co-defendant Percival would have passed that particular address? That corresponds to the time period in which the officers lost view of the car?
Well, it's not clear.
Would you agree with that?
We know that where they were located was that it was in the area where for 1 to 3 seconds there was a blind spot as they turned a corner during this chase. But there's no indication that that's when the guns were deposited at all. All we know from the evidence is that that location, that geographical location, was on the passenger side of the car in the area where they lost sight of of Percival as he was fleeing and they turned the corner. But there's no indication of time. We can reasonably infer the guns hadn't been there forever, but they could have been there easily for like a half an hour without anyone picking them up. We don't know exactly how many pedestrians, how many cars were on the street. We just know we do not have deserted circumstances, which were so crucial to the disposition in Jefferson.
Okay. Thank you very much. I'm going to, if you don't have anything else to tell us, which of course you certainly still have some time to argue if you would like to, but if not, I'm just going to check to see if Justice Milkey or Ditkoff have any questions.
Sounds great. Thank you. Any questions? I'm happy to answer them.
I see no questions from the panel. So thank you very much again for your patience and thank you for your argument. And we'll turn now to the attorney for the Commonwealth. Thank you.
Sorry, Your Honors, I had trouble with my mute button.
Good morning. All right. Your time has just started. Good morning.
Good morning. May it please the court. Houston Armstrong on behalf of the Commonwealth. I'd also like to acknowledge the trial prosecutor, Caitlin Fitzgerald, who is watching via this court's remote live stream. This court should affirm the defendant's conviction for possession of a firearm. Here, under either a constructive possession or joint venture theory, there was sufficient evidence to prove beyond a reasonable doubt that Mr. DASILVA possessed the two firearms at issue in this case. And specifically, I would point this court to 7 facts that establish proof beyond a reasonable doubt that Mr. DASILVA possessed those guns. The first is the location of the guns. The second is the condition of the guns. The third is the police losing sight of the defendants in front of High Street. The fourth is the passenger, Mr. DASILVA's window down during the chase. The fifth is that their guns were found in front of 28 High Street 4 minutes after the defendant's car was stopped. Sixth, the flight path of the car. Okay, and seventh.
Oh, sorry, I'll let you go. 7.
The seventh one was that the car was stopped a quarter of a mile away from where the guns were found at 28 High Street.
Now, counsel, I understand the passenger window was open and the guns may have been found on that side of the car's travel. Couldn't the driver have thrown the guns out the passenger side window?
Could have, certainly. But when you're reviewing the sufficiency here, we're looking at the evidence in the light most favorable to the Commonwealth, and all reasonable inferences are drawn in the Commonwealth's favor.
True enough, but the issue isn't whether it was likely to have come from the passenger. It's whether the jury could have found beyond a reasonable doubt based on that. What is the evidence that the passenger possessed the gun other than the fact that the guns may have been thrown out his window?
Well, that fact in and of itself is sufficient to establish possession. Is that
Beyond a reasonable doubt?
Absolutely, Your Honor. Yes. And the facts that I would point to that I already mentioned are the locations of the gun that came from the passenger side of the car, the condition of the guns, the significant scratches that the jury were able to see the pictures as well as see the gun themselves. They were able to evaluate that to look and see whether or not, contrary to the defendant's argument that somebody dropped by and two guns coincidentally fell out of their pockets walking into 28 High Street. The jury was also able to hear from the police officer that that window was down immediately after leaving High Street. All of those support the reasonable inference, which again must be drawn in the Commonwealth's favor, that the gun was thrown out of defendant DaSilva's open passenger window.
Now, one big difference between the facts in this case and the facts in Jefferson is the two rear seat passengers. There's 4 people in this car rather than fewer.
Sure.
I personally, I see that as a big distinction, a significant distinction between this case, the facts in this case, and the facts in Jefferson. And as Attorney Oren has pointed out, in that case already, I believe it was Chief Justice Gant said that it was a very close case.
Certainly, Your Honor. And to your distinguishing factor for being 4 people in the car, the only evidence that the jury heard was that the front seat passenger's window was down. They did not hear that any other windows were down. And I think my position would be that all of those passengers could have had constructive possession of the guns as well, and or were joint venturers, co-venturers in possessing the guns. However, the 2 passengers, that question doesn't diminish the evidence against Mr. Percival, the driver, as well as for here, Mr. DaSilva. All of these facts, the facts that I laid out are reviewed in the light most favorable to the Commonwealth. And the Commonwealth, in proving their case, doesn't have to explain away certain innocent explanations.
Sure.
Am I wrong in thinking that there was a backseat passenger in Jefferson that wasn't charged?
I don't think so.
If I may just have one moment, Your Honor.
Note 3?
Yes, Your Honor. There was the driver, the front seat passenger, as well as the backseat passenger.
Driver, front seat passenger.
And that's on page 824 of the decision. So that's I think that supports the argument here of that all of the passengers could have been constructively possessed the firearms or been joint venturers. But even more important is the standard.
The record indicates that the other 2 people were charged, but of course the jury wouldn't have known that. That was a discussion that happened towards the charge conference, I guess.
That's correct. That was not. The jury understood that there were 2 other passengers in the car, but they didn't know what happened with them. But that doesn't negate the importance of the facts that I laid out to you, which do establish established beyond a reasonable doubt that the defendants possess these guns. Specifically for constructive possession, it establishes the knowledge and the ability and intent to maintain dominion and control over these guns. Or for joint venture, it establishes knowing participation with the shared intent. And just briefly, I would run through those facts again and the inferences that the jury could have drawn, which again must be drawn in the Commonwealth's favor.
Well, time out.
Sure.
You seem to make that leap, that if a reasonable inference can be drawn in the Commonwealth's favor, it must be, and the Commonwealth wins. You kind of skip a step in terms of the Lattimore standard, including some quantum of evidence that's enough to get it beyond a reasonable doubt. It obviously isn't whether we think beyond a reasonable doubt, but whether or not a reasonable jury could. So even though
any rational trier fact.
Yeah. So
right.
Even if the jury rationally could conclude that it's a likely inference that the passenger possess the gun, that may or may not be enough, correct?
So I just want to clarify your question. Is your question that if you look at all of those facts and draw all those inferences in the Commonwealth's favor, is that enough? Is that sufficient? Is that legally sufficient to establish illegal possession of the firearm? Is that your question?
Yes. Yeah. I mean, assume we know it came out of the car, and the window was down. It came out of the passenger side. So assume it's a reasonable inference that the passenger held the guns for at least an instant before tossing them out the car. Is that it? The fact that that may be likely isn't by itself enough under Lattimore, is it?
I would disagree with your second characterization, but as to your first hypothetical, if the passenger had the gun in his hands and threw it out of the window, that's actual possession. That's proof beyond a reasonable doubt of actual.
I understand that, but my point is simply the fact that it's the reasonable inference that it's likely may or may not be enough to satisfy the Lattimore standard.
Sure. I understand what you're saying. And I would say here it is sufficient. It does satisfy the Lattimore standard. And I would point this court to Commonwealth versus Jefferson that have very similar facts. And in fact, I think there are a few distinguishing facts of our case and Jefferson that make this case even stronger. First would be that it was 4 o'clock in the afternoon in a moderately trafficked area. The probability of somebody walking by and dropping two guns on the sidewalk at 28 High Street at 4 o'clock in the afternoon seems completely unreasonable. And then the fact that they would be laying there for any period of time also seems equally as unreasonable, as Justice Ditkoff pointed out in my sister's argument. I would also, another distinguishing factor.
Let me ask you a question about the damage to the firearms.
Sure.
There was no actual testimony. You said the firearms were introduced as exhibits. So we of course haven't seen them, but there was no testimony with respect to the types of scratches, the types of dents, etc., with respect to the firearms, or real explanation as to how the magazine could have been ejected, other than to say that by being flung and hitting the steps or the sidewalk.
Well, and I think that's sufficient. I think that's when the jury's allowed to use their common sense and life experiences to see the actual gun, hold the gun, feel the metal, the sturdiness of the gun, and then look at these scratches and think to themselves, well, is it more reasonable that these fell out of somebody's pocket, not very high, two guns out of one person's pocket, or is it more likely than not that when the police lose sight of this car at the beginning of High Street, Mr. DaSilva threw both of these guns out of the car, and because they landed on the concrete, they got those significant scratches as well as the magazine being ejected.
Okay.
And to kind of piggyback on my initial point, another distinguishing factor from Jefferson in this case is that there's two guns. And I think that makes it even more likely, and the inference stronger, that two guns came from this car the moment that the police lost sight of them. And if the court have no further questions about Mr. DaSilva's involvement, I would just ask this court affirm his conviction for illegal possession of a firearm.
All right, I see no further questions of you with respect to this case. So thank you very much for your argument. And technically, before we begin, Attorney Combs, I'm going to call the next case. I'll check with our clerk and make sure that I'm not missing any step in between.
No, Judge, as long you can just start.
Okay, great. So Attorney Combs, you're going to be next, but I'm going to call the case number. This would be case number 2020-0599. And I'm not so sure I called the case the last time. What we just heard was 2020-0598. Attorney Combs, please go ahead.
Good morning. May it please the court, Thomas Combs for Mr. Percival. As I was preparing for this case today and listening to the arguments that preceded me, I keep coming back to the following analysis, that the actions within the car at the specific moments, and really here it's just a matter of seconds, that's the crucial period of time, that very limited period of time that we really don't have a lot of insight into. So we have to draw inferences from what evidence we do have to try to determine not just exactly what happened within that car, but with respect to Mr. Percival, what was his intent in that moment? Again, what the evidence showed is that the stop sign, the rolling through the stop sign, the police turn around, they go after the car that the defendants are in. The car takes what's I think described as a quick left, it's essentially the first left as you're going. Then the police lose sight for just a couple seconds, and then they regain a view of the vehicle on High Street. So again, the crucial question for me is what is the intent, specifically with respect to my case with Mr. Percival? In Jefferson, you have two things to my mind that really actually give you insight into the intent of the driver. And I'll outline those two things that I have in my brief. One is this action, not just of flight, but of something far more intentional than that, where the driver in Jefferson stops, comes to a full stop. The police come to a full stop behind them. Police officer gets out of the car, and only when he's out of the car and then approaching the suspect vehicle, then the vehicle peels off and it drives away at a high rate of speed. And then there's this chase through the city. That's a very, very different case than what we have here, where again, the police see this rolling through the stop sign. The car takes a quick left turn, is on High Street. They lose sight for only a few seconds, and then they see the car on High Street immediately after that. The degree of intentionality, the insight that gives us into the potential state of mind of the driver in Jefferson is far different from here. But Jefferson gives us something additional as well at the end of the interaction with the police. It's the statements that were mentioned earlier, where the driver in that case appears to make some statement that's characterized as conscious of guilt, where he seems relieved or he becomes cocky, I think is the word that the Jefferson opinion uses once he's pulled over. The assumption being, or rather the inference being, that he is relieved that there's not a more serious charge when he's informed that they're only arresting him for a motor vehicle offense. So in Jefferson, you really had, strong inferences from that evidence that just don't exist here. So with respect to Mr. Percival, when we're thinking about not just, knowledge, as we know from Romero and other cases, possession is not just knowledge, it's not just ability, but separately, it's did he have the intent to control those items, assuming for the sake of argument in this scenario that they were thrown from that car. That evidence just doesn't exist here. So I think right from the start, with respect to Mr. Percival, his case is in a very different place than the case in Jefferson. There are other facts in Jefferson, which I've outlined, which are absent here. Obviously, the time of day is different. The characteristics of the chase that I've mentioned before are very different. The lack of any information of the residents of the High Street address. I take the SJC at its word in Jefferson that it found meaningful that there was, I believe, live testimony, or at least some evidence came in some form, that the residents in Jefferson where the firearms are found gave some sort of statement to police or some sort of statement to the jury that came into the record in that case, that the guns weren't there, that there was no one that reasonably would have put them there, that she'd never seen them there in I think 20 years. It does appear that the police spoke to the people that lived there, but they don't make any mention of what those people said, whether those people were, there's a lot of coming and going at that time. So again, I mention only because the SJC found it important enough that it mentioned that in Jefferson. I think I certainly would agree with the co-defendant in this case that Jefferson in a certain way actually does provide a lot of support for the defendants in this case, that the evidence as compared with that of Jefferson makes this case insufficient as a matter of law. I still want to save time for any questions that the panel might have.
Well, I think I have no questions. I think you've explained your position very well. Let me check with Justice Milkey and Justice Ditkoff. No questions there either. Thank you very much, Attorney Combs. So we'll hear again now from Attorney Houston.
Thank you, Your Honor.
Sorry, Attorney Armstrong. I'm sorry. Excuse me about that.
That's okay. That's quite all right. Good morning again, Houston Armstrong on behalf of the Commonwealth. I would also like to acknowledge Assistant District Attorney Caitlin Fitzgerald, who is the trial prosecutor of this case. This court should affirm the defendant's conviction for illegal possession of a firearm. And I will start where my brother started with the intent which is absolutely an important part and a required part that the Commonwealth must prove beyond a reasonable doubt. But I think that there's two important pieces of this case that establish Mr. Percival's shared intent, that being the disposal of those guns. The first is the flight, and that's a little bit bigger than just the flight. It is the taking off of the flight, recognizing that the police officers who he just drove by are facing the wrong direction, and him understanding that they're going to have to turn around to follow him. And that actually comes from the transcript on page 1 at 133. The officers were facing the opposite direction. So he understood that the police would have to turn around, and they were quickly going to do that and then catch up behind them. So the only opportunity they had to dispose of those firearms was at the beginning of High Street. The second portion of flight that shows knowledge and intent is the specific route that they took. If you pull it up on a map and you follow it, Mr. Percival was taking every turn that was available to him as quickly as possible for as long as the flight, for as long as the chase lasted. Specifically, he took that first left onto High Street, which gave them the opportunity to throw the guns out of the car. Next, he took a very sharp left onto Hancock, and then an even quicker right onto DeWolf, which was when the police saw the passenger window open. Then as he came to the end of DeWolf, he turned right onto Downer, and then quickly on to Pleasant Street, where the chase ended at the intersection of Pleasant Street and Savin Hill. So that route, to me, they're trying to distance themselves from the guns that they threw out of the car. So I'm
counting 4 turns in your rendition of the evidence, which was easier to do than following through the testimony. Am I correct?
It depends on where you start. I would count it as 5. So the first turn would be on High Street.
That was that was a left onto High Street. The first.
Yes, Your Honor. The second would be a left onto Hancock. The third would be a right onto DeWolf. The fourth would be a right onto Downer, and the fifth would be a left onto Pleasant.
Counsel, aren't there multiple reasons that the driver could be seeking to evade the police?
Sure, certainly. But again, here, Your Honor, we're looking at the evidence in the light most favorable to the Commonwealth and what the jury could have found. And here, the jury
beyond a reasonable doubt.
Again, yes, absolutely. And I think when you look at the path that the car took, and then again, Mr. Percival putting a significant might be too strong of a word, but a good amount of distance between him, their car, and where the guns were disposed of, just like the court found in Jefferson, that goes towards their intent, their intention of trying to dispose of the guns so that they're not found in the car when the car is stopped. And, if all things go according to their plan, then the guns wouldn't be found at all because the police wouldn't have been able to find them on the car. So those would be the 2 points, the 2 facts that I would point to that go towards Mr. Percival's shared intent in this case, that established that him and Mr. DaSilva illegally possessed those firearms. And if there's no further questions on the sufficiency portion, I would just like to mention, because it was not briefed, my brother's argument about a specific unanimity instruction, and just simply say that a specific unanimity instruction is only applicable when there are multiple instances which could have caused the charged conduct. Here, there was not that. It was just throwing each gun out of the window, which each count was represented by, one gun, one charge of illegal possession. If there's no further questions.
I have one, counsel. I'm embarrassed that I can't think of the name of the case, but 2 or 3 years ago, the SJC had a case that involved witnesses seeing a gun being passed around among 4 passengers in a car. And I believe the Commonwealth charged everybody with possession. And the SJC, as I remember the case, said, no, not enough. Sometimes when you have these, joint cases where there's one gun and several people, you don't get to charge everyone just because, even under circumstances where it's being handled. Do you remember that case?
I don't, Your Honor. Not
Okay.
not off the top of my head. I'm sorry.
Well, I can't either, so don't be embarrassed.
We're going to wait for Justice Ditkoff to come up with it.
Have it. I'll find it though.
All right. Any further questions from the panel? I see none. All right. Thank you both very much for your arguments. Thank you as well, Attorney Erroneous. I see you're still on. We appreciate it. They were very helpful, and we will take the case under advisement, get back to you as soon as possible. And meanwhile, on the part of the panel, we hope all of you and your families stay safe and healthy during these times. Okay.
Thank you, Your Honors.
Had some technical difficulties. We resolved them all. And let's just keep our fingers crossed we don't have any during this argument, but if so, please be patient with us. We'll be patient with you if anything goes wrong at your end as well. So with that said, let's begin. Attorney Monroe, the floor is yours.
Thank you. Members of the panel, may it please the court, Barb Monroe for the defendant in this case, Paul Fahey. The foundation of our justice system is to ensure that a defendant receives a fair trial where the outcome is based on facts, not emotions. Here, to prove his case for murder, one of the things the prosecutor was required to prove beyond a reasonable doubt was which act caused Mr. Boudreaux's death. Instead, what he told the jury he had proved was that Mr. Fahey was a cowardly bully and that the entire case was simply about a bully who decided to victimize a more vulnerable person. The trial built around such a characterization, along with a multitude of other errors by the prosecutor, the judge, and trial counsel, can never be fair. This trial was so laden with errors, it's difficult to know where to start, but I would like to talk about 3 areas which are intertwined with each other. The first area would be the erroneous and missing jury instructions, then the inordinate amount of prejudice introduced into the case by the prosecutor, and the third would be the lack of proof beyond a reasonable doubt as to the act that caused Mr. Boudreaux's death. So moving to the jury instructions, the combination of the errors, omissions, and confusion in the jury instructions should lead this court to the conclusion that it cannot be sure whether the jury's verdict is true or whether there might have been a different outcome if the proper instructions were given. The main issue here is that the judge erred by giving the acquittal first rule. Now in that, what the judge instructs the jury to do is that they must acquit unanimously of the greater offense before moving on to the lesser offense.
Counsel, can I interrupt you for a sec? Speaking frankly, I'm having trouble with this first argument in the following sense. The issue of whether or not the Commonwealth has a hard landing, hard transition, soft landing, whatever you want to call these different options, has an angels on the head of a pin quality about it, with the exception of it really having some bite in the context when the jury is deadlocked or approaching a deadlock. That's when this matters. And maybe I'm missing something, but I don't think there's any showing in this case of any deadlock or frankly any difficulty the jury had in making a decision here. So how does this matter in this case?
I'll tell you that the way it matters in this case is that in 2013, in the jury instructions, it was set out, and that's what the judge read, as the acquittal first rule. However, in 2014, in Figueroa, which was about a deadlocked jury, what the court chose to talk about at that point was to point out as an aside note that rule and that instruction was incorrect, and that from that point going forward, the correct instruction should not be based on the acquittal first rule, because that's not how Massachusetts is. And so it clearly stated what the correct version should be when giving all of the jury instructions. And in the 2018 instructions, which was after trial, that was reflected. So here, if they had given the correct ruling, we don't know what the jury would have done as far as moving down to possibly manslaughter. It's quite possible that they did acquit completely on first degree murder because the jury is presumed to follow the instructions. So if they're presumed to follow the instructions, when they were then instructed that in order to get to any of the lesser included offenses after that, they would have been required to unanimously acquit of second degree murder. And they didn't acquit of second degree murder. So we don't know whether that's a true verdict or whether it's not a true verdict, and whether they actually moved on or not. And then when you combine the rest of the prejudice in this case, it's impossible to me to say that there was a fair trial here. But from the start, the jury instructions were incorrect.
I'm going to say, Justice Ditkoff, you have to come a little forward into the microphone. Thank you.
On the instructions, how is your case different than Howard?
Howard is different because there, the only instruction they were referring to was voluntary manslaughter. And it's unclear, actually. They dropped it in a footnote and said that the acquittal first instruction was not given. And then they made it clear that the jury was instructed on voluntary manslaughter because they talked about the mitigating circumstances. So here, what I'm also referring to is that they never were able to get to involuntary manslaughter, and that was never discussed in Howard. And those are the only two cases that are available at this point in time on this rule that is existing in the current jury instructions. So that's how it is differentiated. And the Commonwealth does not address in their argument here at all about what would happen if they had been given the option to discuss and go down to the next involuntary manslaughter. So again, we don't know, and that's where the real prejudice comes, is we don't know what the jury was thinking. And if, as they are presumed to follow the instructions, they followed the instructions, then they could have stopped at second degree, and we don't know if that's a true verdict. So that's how it does differentiate. I hope that answers your question. But then when you move on to the other issue too, is that the trial counsel did not request a instruction on wanton and reckless theory of involuntary manslaughter. There's no reason, manifestly unreasonable for him not to have requested that, because he was not doing an all or nothing approach here. And I believe that the language in that would have been more in line with what could have been found by the jury, because the difference there is when he just gave the battery instruction version, all that talks about is endangering human life. That language is not present in the wanton and reckless. And there it's just about a high degree likelihood of substantial harm because of indifference to or disregard of the consequences. So in the wanton and reckless, it focuses more on the conduct in general, which could have been the punch and then hitting the floor. Whereas the battery theory is solely, I would argue, based on the punch, because then the floor comes after the punch. So not giving that instruction too, we don't know what the jury would have done if they had even been allowed to go there. But the more troubling aspects also of this case is the enormous prejudice that came in. The prosecutor, as I stated, started this case in his closing stating that this was a case about a bully versus a vulnerable person. And that's exactly how he ended his argument as well. As we know, words like that, denigrating somebody like that is not allowed. And numerous cases, this court and our Supreme Judicial Court have reversed on that alone. 19 pages, although that's not necessarily a tracking numbers per se, but 13 times over the course of that closing argument, he referred to him as a bully. And even though the jury was instructed on sympathy, it's so permeated, everything permeated this trial that there's no way that this defendant received a fair trial based on the fact of what the act was that caused Mr. Boudreaux's death. the booking photo, that was used specifically for a prop at the end of the closing argument, where the prosecutor held up a picture of Mr. Boudreaux, and then he held up next to it a photo of Mr. Fahey and compared the two and said, here's the bully that came across this person and killed him. It just doesn't get any worse than that, in my opinion. And then when the problem too is that we don't know, as the medical examiner clarified, what the cause of death was here. So that matters, because if the cause of death was a punch and hitting the floor, then it's clearly manslaughter, unless it's self-defense, which is another issue, but it's clearly manslaughter. So if you have a stomp, which is what the Commonwealth alleges, there is no case law to date that states punch.
The counsel,
Yes.
assume in my hypothetical that the jury could have ruled out the earlier altercation with the, I think it was the brother-in-law, in terms of the cause of death. So the cause of death was either the punch, or for that matter, the hitting of the floor, or the, if the jury found that in fact he had stomped on the head. So we don't know which of those three events, if you will, caused the death. Would that in fact really matter, in the sense of, if he was going to die from the punch and the fall, but then he stomped on the head, couldn't that still be a murder case?
I would say no. And the reason I say no is because it is a fine distinction. As I was saying, is that if it's just a punch, and the case law is very clear that a punch is manslaughter, no more. Pushing somebody, punching somebody, and them hitting their head is also manslaughter. There are no cases, and the Commonwealth cases that they cite to do not stand for the proposition that if you, one stomp, if there was a stomp, one stomp is sufficient for a charge or conviction of murder. There's no case law. The two cases that the Commonwealth refers to are about multiple kicks and multiple punches. And
let me just clarify something, because of course in this case we have two events. We have the punch, someone's knocked out cold, hits the floor, and then for purposes of the argument, let's just say that there was there was sufficient evidence for the jury to find that the defendant then intentionally stomped on him at some point. Some say the head, some or not. Okay, so that is multiple. There's a punch and a stomp. Why doesn't that make a difference? And why doesn't that fall in the same category of cases that you're citing to now, in which the courts have said multiple infliction of multiple injuries is sufficient?
If you give, let me give you an example of if it was a stabbing and a shooting at the same time, both of those independently would be sufficient for a murder charge. But here, because only one of them would be sufficient for manslaughter and one would be possibly sufficient for murder, if the cause of death is unknown, what the mechanism of that act, then there's not proof beyond a reasonable doubt as to what the cause, the mechanism was. So it could have been.
Why are you saying that the cause of death is unknown?
The medical examiner testified that he could not really explain whether it was, the cause was a fist, a punch to the nose,
or a stomp.
The stomp or the floor. He could not distinguish between those in the
Well, counsel, I'm not sure that's entirely accurate, because, for example, with regard to the earlier altercation, I believe he said it was unlikely that would have been the cause.
Yes, he did. He said that a slap to the face was unlikely, a whack to the side of the head possibly. So even if we discount Eric Manley's piece in this, you still are left with a punch, the floor, and a boot.
Okay, but counsel, if there had been a punch and then he pulled out a gun and shot him, and the medical examiner said, I don't know if the punch killed him or the shot killed him, you're not suggesting, I would think, that he couldn't be convicted of murder, because we don't know, he might have died anyway from the punch.
No, I would not say that. I would agree with you, right? But the difference there is that there's no case, again, I hate to keep stressing this, but there's no case in this Commonwealth that states that one punch is sufficient to support a murder conviction.
But I take it there's not a case that says a stomp on the side of someone's head when they're against a hard floor is not sufficient.
There's a case that goes back to 1858 where they said he threw her down on the ground. That's Commonwealth v. Fox. He threw her down on the ground and he kicked her with his hands and feet, kicking her and bruising her. And that was clearly manslaughter. They said it was not sufficient for murder. Hadley is another one where he's indicted for first-degree murder and charged in all the same ones here. And there he kicked the inmate in the mouth and the torso as he tried to get up, and he died from an injury to the spleen, and that was still considered manslaughter.
Jury.
I
No one
cannot
said,
find any case where one stomp. But
Hadley,
the problem is too, is
One second, Attorney Monroe, Justice Ditkoff has a question.
Hadley, the court didn't say that was insufficient for murder, did it?
excuse me?
No court said that was insufficient for murder in Hadley, just like in Shepherd. There was no finding that it was insufficient, just that it was sufficient for manslaughter.
There's no court that I could find that says that is sufficient. They didn't say, you're correct, it didn't say it was insufficient, but there's nothing that says that. And then it all goes back to the problem of the incorrect jury instructions. We don't know what the jury thought or what they found. And then all the other prejudice that came in this case, it doesn't seem that it was a fair trial to me at all when it was about a bully and not about what the cause of death was.
I appreciate your view of the case and your advocacy that this not, in your view, is not a fair trial. But what do you say about the fact that so much of what you are brought to our attention now was not objected to at trial?
Well, I would say that that was a poor part of trial counsel's job, probably. And I can't speak for what he did, but
well, I was thinking in particular about the cross-examination of the defendant, on which there were some objections, and those objections were sustained, but many of the comments that you've brought to our attention, and legitimately so, were not objected to. And, you know, we've all been in the courtroom, and in the courtroom is a different place than reading the transcript. And your client actually answered the questions very well. It seemed that there was no composure lost on his part. Again, reading just the transcript, he didn't waver on his position or on his history of his defense. And it may very well have been a good tactic to let the prosecutor, you know, do his best and to show the jury that your client was still telling the truth.
well, what I could say about that is that he did object, you're correct, in the cross-examination. I believe he objected quite a few times when the
right, and that says to me that he objected when it was necessary and didn't object for a reason in other parts of the cross-examination.
I would disagree with that only because as when the prosecutor was questioning him about when did he form his intent to kill, he objected quite profusely. And then the prosecutor just kept rephrasing it 13 different times.
So counsel, are you making a form of a futility argument that if the objection doesn't do, then sustained, doesn't do anything to change the prosecutor's conduct, there's no reason to keep objecting?
I could make it, I don't know what his purpose for not, but
he could have gone a sidebar and talked to talk to the judge about what was going on.
Because at some point, you know, I would think that a jury could possibly get annoyed with him keep objecting. And especially during the defendant's cross-examination, I can't infer what he was doing, but if it seems like he doesn't want his client to answer questions, that may not bode well for the defendant, I would say. But just the enormous amount of prejudice in this case alone seems to me that it should be overturned. If there's any other questions, I'd rest on my brief.
Yeah, I just want to note for the record, the clock got reset at some point. So
yeah,
we're about down to 0 by my count.
Okay, I figured. Thank you.
All right. Thank you very much for your argument. All right. So now we'll turn to Attorney McGee.
Thank you, Your Honor, and may it please the court, Michael McGee for the Commonwealth. I'll jump right into the jury instruction issues that counsel's raised. The judge's instructions regarding voluntary manslaughter did not create a substantial risk of miscarriage of justice. The judge correctly instructed the jury to consider voluntary manslaughter based on excessive use of force in self-defense or defense of others before reaching a decision on murder. What's important to note here is the basis of these instructions and the self-defense instructions was a self-serving and uncorroborated story by the defendant that the victim made a sudden movement. All other witnesses described an unprovoked attack on a defenseless drunk victim who had no prior interaction with the defendant at the bar that day. That being said, the judge's instructions properly informed the jury of their obligation to consider the mitigating circumstance of excessive force in self-defense or defense of another.
Counsel, it may be helpful to move on to the prosecutorial misconduct issues.
I would suggest that the use of the word bully, and I believe you're referencing the closing argument, Your Honor.
And the cross-examination.
And the use of the photos during closing argument.
What I would suggest to the court is that the prosecutor's repetitive references to the defendant as a bully might have been excessive, but there was an abundant amount of evidence of the defendant's unprovoked attack on a vulnerable victim and his intimidating conduct. Thus, it was unlikely the jury was swayed by the use of the word bully. This is an individual that was wearing a hat that said bully squad, was wearing boots. He punched a defenseless victim who was drunk, who was not looking at him, and he struck the ground, was unconscious, and that the defendant then struck the victim with a boot, and it made a sound as a thud. He dragged him across the floor of the bar, brought him outside, put cold water on his face, told the bar owner not to call the police, from the bar owner not to do that, and then bragged about it to customers.
Counsel, in those cases that say that prosecutors can't use invective against the defendant, they don't turn on whether or not there's support for it. And if perhaps the defendant is a monster in a case where that was used, and the SJC said you can't do that. So I'm not sure you're pointing to evidence that might suggest he was a bully is material to the question of whether or not this was improper conduct.
Your Honor, and raises an interesting point about the word monster. The Commonwealth versus Boyce case, where the prosecutor did describe a defendant as a monster. The court found that in that case it was improper for the prosecutor to use that word. However, that the jury was unlikely to be swayed because of the overwhelming evidence in the case.
Okay, well, let's talk about the overwhelming evidence here, because the Commonwealth had very strong evidence that the defendant, with no or at least insufficient provocation out of the blue, cold-cocked the victim, causing him to be thrown to the ground, probably knocked out. And then there was also strong evidence that the defendant stomped on him. But there is frankly, quite arguably not strong evidence that he stomped on his head. When the only witness to that effect, there are various reasons why a jury might, an unswayed jury might question the veracity of that evidence and the capacity for that particular eyewitness to see the kick. Moreover, as was uncontested, there were no signs on the side of the victim's head that he had just been stomped with a heavy work boot. So the Commonwealth may have had overwhelming evidence of manslaughter, but I frankly don't think it's accurate to say there was overwhelming evidence of murder, where the murder case seemed to rest on the stomp to the head.
I was just, Your Honor, the two independent witnesses, Sullivan and Anderson, saw the defendant's leg go up and down. They heard it, and they both testified to this sound. But
what, counsel, where did
the foot, right?
Where did the foot come down in contact with the head? And what I can say is that Dr. Welton testified that the manner of death was blunt force trauma. They also observed photographs of that. Additionally, Dr. Welton testified that the mechanism of injury could be consistent with being caused by someone stepping on the head, and that was it.
No, I understand that, but he also testified it was consistent with someone getting punched, correct?
Correct. But
we can't tell from the medical evidence that that he stomped on the head, correct?
But collectively, with the eyewitness testimony and the sounds that they heard, and the defendant bragging about his actions and it being on video of him to customers outside.
But he didn't brag about where he stomped on where his foot hit the victim in this case, correct?
He said he stomped on the head. He stomped on him. But what is the only thing that is missing here, and I think of the mailbox description when a judge instructs a jury on reasonable inferences, is you have two witnesses that see a leg go up and a leg go down and they hear a thud, and that the only thing that's not visible on that video is it actually coming contact with the head. And you have an individual that has suffered a blunt force trauma to his head. I think a reasonable inference for the jury is that the foot did.
And correct me if I'm wrong, the autopsy did not reveal a significant injury to another part of the body, correct? Like to the shoulder, or to the back, or to the stomach, or the spleen.
Correct.
What about the fact that the defendant tries to revive the victim, stays there and discusses what he said, and the injury is such that it doesn't cause death for quite some time? I mean, how strong really is your evidence of intent to kill or create grievous bodily injury where the defendant actually seems to be trying to revive the person?
Well, what I would suggest to Your Honor is that if believed that he did care for him by throwing cold water on him, the jury would have weighed that. This is a second-degree verdict, and the jury here did find that he created a plain and strong likelihood that death would result, rather than that he did do so by extreme atrocity and cruelty. So that's I would suggest the distinction there. But the act of itself of punching and stomping on an unconscious person, dragging them across the floor, threatening a bar owner, and then leaving before the ambulance could arrive.
Could we go back to the use of the photos during the closing? Prosecutor puts up two side-by-side photos, the carefully curated photograph of the victim and the mugshot of the defendant, and says, innocent victim, bully. Why isn't that sort of, again, using these photographs as props, as your sister said, why isn't the prosecutor in effect asking the jury to choose sides?
What I would suggest is that it was grounded in the evidence. You have an individual that outweighed the victim by 70 pounds. And you have a victim here that is
Can you tell that from the headshot of the victim?
I believe you can. You can tell by his neck, the size of his head, his shoulders, and then you have a fairly small victim here. And by all accounts, you have an undersized victim who's undisputedly drunk and standing and not looking at the defendant, and is, as Your Honor described it, cold-cocked by the defendant to the point where.
Do you agree the pictures were side by side during closing argument?
That I was not clear with, and I believe I addressed that in my brief. I couldn't. I'd have to send a 16L letter if I did know that, but I believe I addressed that in the brief. I don't think that's clear from the record, but I don't want to say one way or the other because I wasn't present at trial.
Counsel, could we address the cross-examination where the prosecutor repeatedly asked, was this the moment that you formed the intent to kill him, or words to that effect? isn't that, a classic when did you stop beating your wife question that is improper?
I would suggest, for the reasons that Justice Vuono suggested, that it probably hurt the Commonwealth's case more than anything. You have a defendant that's standing by his answer, and he's asked repeatedly. It's certainly not helping the Commonwealth's case at all. Additionally, there were questions.
Doesn't make the questions proper. Line by line, the questions that were posed by the prosecutor here, our cases have said are improper. Many of them.
Many of them. And in this case,
the fact that the defendant did well may go to substantial risk. Certainly that's the case. But please don't take my comments as meaning that I condone in any whatsoever the nature of the questions that were asked here.
No, and what I'd suggest,
demeaning, number one. Number two is also they asked, the defendant was asked to comment on the veracity of other witnesses. Since Commonwealth versus Triplett, that has been, of course, an area where that we all know is taboo. So there were a number of areas in which there was improper comment, improper cross-examination here.
What I would also suggest, though, is that many of the questions were grounded in the evidence. And you had an individual, the defendant here, testified, and he was the only one that testified that he did this in self-defense. He also said that he told the bar owner that he called 911.
Isn't that a problem, though? Because to ask questions about the defendant sitting through the testimony and therefore being able to tailor his testimony and demanding the defendant explain why other witnesses are uncredible goes right to his credibility, which is key when he's the key witness on his own intent and self-defense. So why doesn't those two things, the sitting through the testimony and the credibility of other witnesses, create a substantial risk in a context where his testimony is so important?
Number one, he stood by it. Number two, I would say that it was grounded in the evidence. And I think that when somebody testifies to something and it's inconsistent with another witness, it's perfect fodder for cross-examination. And additionally, the jury was instructed on not to be swayed by passion or anything like that, and that the lawyers are advocates. And on the intent issue, the issue of premeditated murder was rejected by the jury. So there's some sophistication here that is evident from the verdict, where not only first-degree murder was rejected, but also the intimidation of a witness charge was also rejected. So the jury was thoughtful here and listened to the judge's instructions and was not swayed by any, if your honors find it to be improper cross-examination or closing argument.
I take it from the transcript, this case got a lot of press. There's one portion of the transcript where it comes out that there apparently is a video camera filming against the judge's wishes.
There was a reporter in the courtroom that was video. Yeah.
I'm not sure about that. I wasn't present at trial.
I mean, the reason I ask is because there are suggestions from the prosecutor's conduct that he is playing to the cameras.
Oh, I would reject that. I don't believe that at all. I would say that the cross-examination and much of the closing argument was grounded in the facts
But counsel, that alone doesn't make it proper.
What I would also suggest, and this is a point to be made, is that we are reviewing that your honors are reviewing a transcript. There was no objection made here. An important aspect here is that these words taken now and counted for an appellate brief may not have been how it appeared to the court and to the jury as it happened during the trial.
Well, counsel, where the series of improper questions was being asked on cross, and every time the defendant objected, it was sustained, and the prosecutor kept going down the same lines. At some point, as defense counsel, aren't you going to stop and say, why bother? it's only going to make the jury mad, and he's not changing his conduct?
Well, we don't know that. There was no motion for a new trial. There was no evidentiary hearing on that issue. What we do know, or what I can also suggest to counter that, is that the attorney may not have, he may have liked the answers that his client was responding with. And it very well maybe was helping their case. We don't know that, but we do know that they were unobjected to, and that there was no intervention from an experienced judge. So what I can take from that is that the answers helped the defendant, and certainly did not hurt him.
So your time is up. I'm going to check with the panel to see if there's any further questions.
Thank you very much.
No, I see no further questions. I want to thank you both. We asked you each very, very tough questions. We pushed you both with respect to what was in the transcript and the law, and we do so we can get to the bottom of all the issues, and we appreciate your responding to our questions, okay? Thank you both. Get the case under advisement. We'll get an answer to you as soon as possible. Meanwhile, we wish you and your families, on behalf of the panel, stay healthy and
We're live.
Thank you very much. All right, good afternoon. The next case on our list today is the Department of Children and Families versus Mother and Others. As you know, the case is impounded or partially impounded. The case number is 2020-0681. I'm Justice Vuono. I'm joined today by my colleagues, Justice Milkey and Justice Ditkoff. As you know, Attorney Krasner, you have 15 minutes to present your argument, and there is no rebuttal. And I understand that Attorneys Sasa and Campbell are splitting their time equally, 7.5 minutes apiece, correct?
That is correct, Your Honor.
Okay, great. With that said, I want to apologize that we're running a little bit late today. We've had a number of technical difficulties, but let's keep our fingers crossed they've all been resolved and we won't have any more during the course of this argument. Attorney Krasner, you may begin your argument, please.
Thank you. Good afternoon. May it please the court, Sherry Krasner on behalf of the mother. I am not going to give mother an opportunity to present evidence. Let me repeat that. I am not going to give mother an opportunity to present evidence. The trial judge here made this draconian pronouncement before she heard DCF's first witness or otherwise had any other evidence before her. Mother understands that trial judges have wide latitude in how cases proceed, and that it is not the job of this court to second guess. But given the constitutional right that is at stake in this proceeding, this court must consider whether the judge did abuse her discretion in denying mother's motion for a continuance. And why did she make this harsh decision to deny mother the constitutional process to which she was due? The judge looked at the same docket that your honors have before you in volume 1 of the record appendix at pages 61 to 63. And she said, well, mother hasn't been here 3 times. That is not what is reflected, or is that's not a full reflection of what the docket showed. On February 7th of 2019, the department filed its motion to dispense with parental rights. And it is true that the docket reflects that mother was not there. However, the docket also reflects that mother's counsel was not present at that proceeding. On March 14th, the matter was before the court on a pretrial. And again, the same docket that the judge looked at and that you can look at in the record appendix indicates that mother was not present.
Actually, counsel, the March 14th was actually the first scheduled termination trial, correct?
No, it was not, Your Honor. March 14th was a pretrial date. And again, the record reflects that mother was not there, but also that her counsel was not there. The first trial date, Justice Milkey, was supposed to be March 27th.
Right.
And on that day, or strike that, the day before, mother's counsel, strike that again, child's counsel filed a fully assented motion to continue the trial because he was being held over in another court. And yes, it is true that mother did not appear on March 27th, but no counsel, no one appeared before the court on March 27th. So when mother's counsel on June 14th made the first request, mother's first request for some sort of continuance, and the judge said, well, no, she could have been here 3 times, that was not a reflection of what had actually occurred, or it wasn't a reflection of what, why mother's reasonable request for a continuance, mother's counsel's reasonable request for a continuance.
Attorney Krasner, 1 second. Justice Ditkoff has a question.
Counsel, you said your client was deprived of her constitutional right. What constitutional right specifically was that?
To defend against the petition, the process to be heard at a meaningful time in a meaningful way.
How was she denied that? All she had to do was show up at trial. She was there. She was in the city. All she had to do was walk into court and she would be heard and she could testify. So how was she deprived of that?
Mother was pregnant. Mother had outstanding warrants, and mother feared that she would be incarcerated. This was not something that was new to the proceeding. If you look at the investigator's report that it's in the record appendix, specifically on volume 1 and page 237.
Why would someone have a due process right to remain a fugitive from justice when they're avoiding prosecution in a criminal case?
Mother should not have to choose respectfully between defending against the criminal case and also against losing her right to a child. And again,
she doesn't have the right not to show up in court at all when she has a criminal conviction. She doesn't have that choice. So why should a juvenile court judge assist the mother in avoiding justice in a district court?
The judge here indicated that at the conclusion of the trial, the first day of trial, the judge indicated that she would hold the proceedings open for 2 weeks, and specifically to a date, June 28th, because this case was on parallel tracks. There was a possibility of a settlement being reached, and the judge indicated that she would allow mother to participate by telephone, but she would only allow her to participate if it was to do a colloquy in which to accept the open adoption.
And counsel, isn't it correct that at no point did mother's trial counsel ask that she testify telephonically in the termination trial?
He did not make the specific request, but he did request both at the beginning of trial and at the conclusion of trial for a continuance. The judge was holding open that June 28th date in order to accept mother's stipulation if that was the decision that mother was making. So certainly implicitly, if not explicitly, he was saying, continue this matter. And if the judge had said, well, we're going to wait until June 28th for mother to come forward on a stipulation, why would she hold the proceedings open for that, but not hold the proceedings open to hear from mother in defense of the petition? And again, too, when the motion for the new trial was advanced, and when the judge denied that motion, she specifically said, and you can read that at page 175 of volume 1, she said, well, one of the reasons I'm not allowing the motion for a new trial is because mother had the opportunity to participate telephonically in this case, and she chose not to. And that's simply a misstatement, and a pretty egregious misstatement of what actually happened. The judge did not permit mother to defend against the petition. She wanted to move cases along. I understand that this court understands that these cases should not languish, but if she was willing to wait.
Counsel, you're doing an excellent job, but you have skipped over the reason the judge said she wasn't going to give the continuance, which was the initial representation by DCF eventually backed up in actual trial testimony that the mother said, I'm not going to show up because I want to delay the proceedings. So there is evidence the judge could and did accept that she was trying intentionally to delay proceedings. And why isn't that sufficient, even apart from the issues that my colleague, Judge Ditkoff, has raised?
Several responses to that. First, the judge made that statement, I'm not going to allow mother to present any evidence, before the social worker actually gave that testimony, when there was just a representation by DCF counsel that that was what he was going to indicate. And also the fact that mother came forward within a matter of days after trial, filing the motion for a new trial, that she was able to clear her warrants. She wanted to present her evidence, certainly show that she wasn't.
Counsel, why doesn't that timing undercut your argument? For the following reason. I think there is at least more than a suggestion in the record that the warrants were outstanding as of February, that your client specifically discussed them with DCF, and I think it was March or April in that time frame. They're still outstanding. Then, as soon as the judge rules, she goes in and clears the warrants.
My response to that, and I can only base what I see in the record, and I did not make an ineffective assistance of trial counsel argument. I didn't advance that argument, but at the same time, we see from the record that there were several proceedings where mother's counsel wasn't present. So what mother knew and didn't know is not completely clear from this record, but certainly that she may have had some frustration with her trial counsel. And again, I'm not raising the ineffective assistance, but the fact that there may have been some communication problems is apparent from just the record that we have before us. So
what is the prejudice here? I do not see any proffer at the trial in terms of what the mother would have testified to. And even on the motion for a new trial, there's only the slimmest of proffers from counsel saying, oh, my client tells me she would have had relevant evidence. Or I'm paraphrasing slightly, but that's the level of generality it had. I don't see anything in terms of I would have countered the Commonwealth's evidence in the following three respects or anything like that.
And how I would respond to that, when we look at the testimony of the social worker, and that's in the approximately page 70 to 73 in the first volume, what he talks about is he wasn't able to confirm whether mother was doing her domestic violence counseling. He wasn't able to confirm whether or not she was doing the substance abuse training. He wasn't able to confirm whether she was meeting with her therapist. So we just know he wasn't able to get that information. We don't know whether or not mother, in fact, had participated in those services. We do know from his testimony that mother had secured housing. That had been an obstacle. We do know that she was coming to visits and that her visits with the child were going well, that the child very much enjoyed seeing his mother. So there was some evidence, but the evidence about her compliance with an action plan, which is critical to a determination of unfitness, I would suggest doesn't rise to the level of clear and convincing evidence. And mother, had she been able to participate in trial on that June 28th date, could in fact have been able to address what services she was participating in. So I think there was prejudice to her from her inability to present, not just that her counsel was there, but to have evidence from mother testifying under oath on the telephone that she was participating in certain services, and the trial judge simply didn't give her that opportunity to
Counsel, you raised an issue of the judge, in a sense, ruling too early, that there was a discussion at the trial about what the judge was going to hold open until the middle of July. And you say, no, in spite of that, the judge then came down on June 28th and issued a decree of termination. I have studied the portions of the transcript that are relevant for this. And to be frank, they are incredibly confusing.
Yes.
And there are places where one attorney or another, or the judge, was saying June and meant July and vice versa. And you can interpret this as the judge did exactly as she said she would, and you can interpret it as there was some confusion at a minimum. My question, though, is, isn't any prejudice that your client suffered from the judge arguably acting too early with regard to some opportunity she lost with respect to the open adoption agreement, and not having anything to do with the termination?
I will agree with you. It's extremely confusing reading the record, but I did spend a lot of time going through it, and I think the representations I made in my brief are correct. I would say if there was prejudice to mother, and this ties into my third argument, it may in fact be related to the fact that the proposed adoptive resource fell through. That it's not completely clear from this record, but it is possible that it was somewhere between June 28th and July 17th that the home that the child had been in, the home that the judge considered a trial, the home that she approved, that resource fell through in that time frame. And so to the extent that that was something mother could have raised, I think she was foreclosed of that opportunity, and that was prejudice to her. And again, if you look at the adoption plan, it did not have an alternative. It did not propose that if the adoption fell through with this particular home, that the department would engage in adoption by recruitment. It only had one option, and that option was that the child was going to be adopted by the foster family with whom he had been living since he had come into care. And although that's not something that the mother normally would have the opportunity to raise, just there's something about the timing that it just doesn't feel right. That the judge had specifically said June 28th, nobody needs to appear. You only need to appear if we're going to be doing the colloquy with mother. Counsel for the child, counsel for mother don't appear on that date, but DCF counsel and the social worker appear, and the judge signs the order, makes her ultimate finding on that day. There's not trying to accuse anyone of any malfeasance, but it's just something about the whole way that came down doesn't feel right, and it did not inure to mother's benefit for that.
Attorney Krasner, your time is actually up. I appreciate your answering Justice Milkey's question, but I see no further questions from the panel, and I do not. Thank you for your argument, and anything you haven't touched upon will be in your brief, and of course it's not waived, and we will consider. So thank you. I'll turn now to attorney for the department. Attorney, is it Saksa? Am I pronouncing it correctly?
That is correct, Your Honor.
Okay. Thank you. In one moment, your time will come up at 7.5 minutes. If it says 7 or 8, it's because I don't know if we've been able to split the time yet. But there we have it. Exactly, 7:30. Perfect. Please begin.
All right. Good afternoon, and may it please the court, Assistant Attorney General Helen Saxa on behalf of the Department of Children and Families. We're asking the court to affirm the judgment of the trial court in all respects and to affirm the denial of mother's motion for a new trial. The judge here acted fully within her discretion when she denied mother's motion for a continuance. And that motion was made, well, first of all, mother had notice of the trial date. and she had an opportunity to be heard through her attorney. Her motion for a continuance was made on the day of trial. It was oral. It was not accompanied by an affidavit, and it presented conflicting factual reasons for the continuance. One was the reason announced first by counsel for the department and later confirmed during testimony that mother had informed her social worker that she knew of the trial date but intended to delay the proceedings by either not appearing or by appearing and firing her attorney. And that was contrasted by mother's counsel, who informed the court that he had had an opportunity to meet with mother the week before trial, that he knew of her pregnancy, of her warrants, of her housing situation, but then said, I would suspect that those are the reasons she's not here. So that indicates that mother had not told her attorney the week before trial that she was so concerned about her warrant or her pregnancy that was going to be the reason for her non-appearance. Her own attorney, reading the transcript in context, it suggests that her attorney expected her to be there that day and made the motion for a continuance spontaneously when she failed to appear that day. In addition,
counsel, can I just interrupt? Why isn't your sister correct, at least as far as she says that it appears that the judge unfairly attributed to the mother any previous delays in this, where as best I can tell, the termination trial got delayed exactly once, and that was at the child's attorney's request?
It is correct that there was one continuance. It was fully agreed upon from March 27th to June 14th. And in fact, the March 14th date was not a trial date, but a pretrial conference. That is not, I know the judge said that, but it is not the only reason that was before her. And it is also not the only reason that she considered in looking at the transcript in its entirety. Because the judge, in fact, considered the fact, the testimony of the social worker, that's on page 54 of the transcript, that mother had indicated she wanted to delay the proceedings. And at the same time, the judge does have to balance the interests of both sides in this case. The child was removed from mother's care in September of 2017, and the case had been pending for quite some time. And now the trial date was June 14th, 2019. That's close to 2 years later. And the judge doesn't only have an interest to move her docket along, but actually has a valid interest in reaching a finality decision for this child. Moreover, mother did not, in fact, present any evidence, neither at trial nor later in her motion for new trial, that she would have presented and wasn't able to bring before the court. And
now, counsel, in her ruling on the motion for a new trial, the judge gave a fairly impressionistic explanation of why she was going that way. Included among the specifically stated reasons was the fact that the judge provided the mother an opportunity to testify telephonically. And it appears from my reading of the various transcripts that the reason the judge remembered it that way was in fact because the agency's counsel and the child's counsel both told the judge at the hearing on the motion for new trial that that had occurred. As the agency now concedes in its brief, that is a false premise. What do we need to do with that? Or put differently, where one of the reasons that the judge relied in denying the motion for new trial was admittedly wrong, do we need to send that back to the judge for her to clarify whether she would have come out the same way without that reason?
Your Honor, the key takeaway from the judge's ruling, the written endorsement of on the motion for new trial, is that the judge found that the mother was aware of the 6/14/19 trial date and engaged in delay tactics. That is the judge's credibility determination, which is fully supported by the evidence, and that alone is enough to support her decision denying the motion for a new trial. I agree that there was that the judge's statement that mother had the opportunity to participate telephonically is, I would say, a mistaken remembrance of what occurred at trial. But it does not affect the judge's decision in this case, because
how do we know that? Don't we need the judge to tell us that it wouldn't affect her decision?
I respectfully submit that you do not, because the motion for new trial is essentially a request of the continuance that was decided on the trial date. And on the trial date, the judge stated unequivocally that she was not going to hear any evidence from mother after the June 14th date, and that the any participation by a telephone was strictly limited to a potential open adoption agreement. I see that my time is up. If the court would like me to, I can finish my answer.
Oh, I'm sorry, it looked like you were frozen for a moment. Please finish.
Thank you. So there was no question what the judge did on the day of trial in denying her mother's motion for a continuance. Her motion for a new trial is simply a request to re-decide the continuance that was requested on the trial date. And under those circumstances, I know it's unfortunate that the judge misremembered the her take on the opportunity for telephonic testimony, but it really does not affect the outcome here and does not require further clarification from the judge, because she was simply asked to redo what she had already done before, which was properly deny a mother's motion for a continuance.
I see no further questions from the panel, and your time is up. So thank you very much for your argument. We'll now hear from Attorney Campbell for the child.
Thank you.
Good afternoon. My name is Alan Campbell, and it's my pleasure to represent the subject child in this matter. I'd actually like to begin by following up on a point that Attorney Saxo was making, that this really was, the motion for new trial was essentially identical to the motion for a continuance.
Mm-hmm.
The only change was at the continuance, counsel says, I suspect it's because of this. And in the motion for new trial, counsel says, mother told me it was because of this. There's no affidavit from mother in the motion for new trial actually even saying this is why it happened. And frankly, the record would contradict that because she had told the social worker beforehand, I'm either going to fire my attorney or not show up so that I can delay resolution of the case. Unfortunately for her, her strategy backfired, but she had missed many, many dates in this case. It wasn't just the one hearing before. She, going back to the very beginning of the case, and I think she missed dates on July 27th, September 13th of 2017, September 12th, November 1st of 2018, and then we roll into 2019. She missed February 2nd, March 14th, March 27th, and 6/14. She, and also then 6/28. She appeared.
To what extent was her presence required or even appropriate at those particular hearings?
I believe that a parent not showing up at a court hearing reflects their actual desire to regain custody of the child, especially when there's such important things as a permanency plan hearing and a trial and the pretrial.
No, but if she doesn't show up at the initial trial date because everyone knows it's going to get continued, how does that show her lack of interest?
I don't know that that's actually accurate. There was an assented to motion to continue the March 27th date, but I believe I heard, and perhaps I misheard, but Mother's counsel saying that nobody showed up on March 27th. If you look at volume 1, page 161, everybody was at trial except for Mother. There were 3 attorneys: DCF's attorney, child's attorney, Mother's attorney were there, and the social worker was there. And although the motion to continue was assented, if you review the docket, there's no action on the motion, and the motion in the appendix isn't endorsed. And Mother has not presented us with the transcript of what happened on March 27th. So we don't actually know whether the child's motion, whether child's motion was allowed, or if it was continued because Mother didn't show. To assume that a motion which isn't, there's no endorsement on the motion, and there's no action in the docket sheets for this court to assume that motion was allowed, I think it's not something this court could do. There was a hearing on that date. We don't know what happened because Mother didn't put it in the appendix. So if the court is going to draw any inference from it, with given Mother's burden as the appellant to present the record, it would be that it was continued because Mother wasn't there. But notwithstanding that, she didn't appear on the 14th. Assuming, yes, for the sake of the argument, that she really wanted to participate in the trial on the 14th, she knew when the trial was. She knows her attorney. We can assume she knows her phone number. She found housing. It's some sort of group home or shelter that provides transportation. Presumably, if she actually wasn't appearing because she was afraid of being detained, she could have used the phone and called her attorney and said, "This is why I'm not here." The attorney could have, perhaps even made an oral motion for her to participate by phone, or if nothing else, to say at the time, "This actually is why Mother is not here. It's because she's afraid." Looking at the record in the case, we know that isn't what happened. She had told the social worker beforehand, a week beforehand, "I'm not going to show up." She had spoken to her trial attorney a week beforehand and didn't say, "I'm not afraid." She didn't talk to, so she had met with the trial counsel about a week beforehand. She doesn't talk to him or her, I forget actually the gender of the attorney. She doesn't talk to her attorney the day of trial. She doesn't talk to him the day after trial. It's not until about 3 weeks after the scheduled date that she somehow gets in touch with her attorney, or they talk, and apparently tells, perhaps with some coaching, "Yeah, I didn't show up because I was afraid on that date, or afraid of getting detained." And that's when the motion for new trial is filed. But to say that the court gave too much weight or unfairly attributed failure to show to Mother, it's just not, that proposition is not supported by this record. Mother has a clear record of not attending. I believe she only attended 3 hearings in the entire 2.5 years that this case was running. Mother was not interested. She wanted to delay. She told the social worker that, and obviously the court credited that because it denied the motion. And Mother's counsel suggests that there was a communication problem. I would agree. The communication problem was that Mother simply wasn't talking to her attorney. She wanted to delay the case. She had no interest in actually having the judge decide the case on the evidence. She just wanted to delay it as long as possible. And there's a suggestion that there's some problem with the way the case was decided, but I would posit there's absolutely nothing, no harm to Mother from a schedule. And again, it is confusing, the schedule of when the decree would enter. Trial was over. There's no right that Mother lost by entering the decree early. If she had a motion to new trial to file, she could have filed it. In fact, she did. The fact that a decree enters doesn't stop her from doing that. And once the trial was over, she had no right to present evidence. She could file a motion to reopen the evidence or things of that nature, but she could do that once the decree was entered too. So I think that's, the timing of that is really a distinction without any difference.
Counsel, without providing any factual details, at least outside the record, can you provide the most basic update about your client in terms of whether or not the child is placed with a different foster family, et cetera?
I apologize if I don't answer correctly according to what you've just said, but I met by Monday on Zoom with my client who's been in a pre-adoptive home for approximately a year, and he's doing great. So I apologize if that wasn't what you were looking for.
Well, my only follow-up question is that this is a different pre-adoptive home, I take it.
I believe it is a different pre-adoptive home, yes. And I believe I've covered all of the points that I had made that I wanted to make based on what happened previously. So unless there are any other questions, I will rest on my brief and just reiterate that the child is asking this court to affirm the judgment below in all aspects.
Okay. Seeing no further questions from the panel, and you're also, your time is also up. I want to thank all three of you very much. The panel is certainly aware of the fact that these cases are always very difficult, and this case in particular presents some very significant issues. So you can be assured that we'll take the case we'll look at the case very seriously, and we'll take the case under advisement. In the meantime, on behalf of the panel, we wish all of you and your families safe and healthy in the upcoming.
We're live.
Okay, thank you very much, and good afternoon. This is our last case of today's hearings, case number 2019-1789, Jennifer Pavia versus Dr. Randy Kaplan. I want to begin by thanking both of you for your patience today. We've had a number of technical difficulties, and so we ran a little bit late, and we're grateful to be able to be on a remote platform, but these are the consequences of that. My name is Justice Vuono. I'm joined today by my colleagues, Justice Milkey and Justice Ditkoff. I'm sure you both know that you each have 15 minutes to make your argument, and there is no rebuttal. So that said, we'll please begin with Attorney Cook on behalf of your client.
Thank you, Justice Vuono. My name is Kathy Jo Cook, and I'm here on behalf of the PAIVAs. We would submit to the court that the judge's charge in this case was error, and that the judgment should be reversed and the case remanded for a new trial. A trial judge is required to give full, fair, correct, and clear instructions so that the jury can understand often very confusing and difficult legal concepts and be able to understand those concepts and render a fair decision. And I would submit that the standard of care instruction in this case was not only not a correct statement of the law, it was not clear, it was not fair, and in some ways irrelevant to the issues the jury had to decide. So what I'd like to do to start with is just a look at the specific charge that is at issue in this case. The very first paragraph of the charge says, part of the standard of care is that the physician will use his or her judgment. And that's really inaccurate because judgment is not always.
Before you tell us why that's inaccurate, in your motion in limine, you asked there to be no instruction about a wide range and reasonable exercise of judgment. You also asked to not have good faith judgment or honest mistake. When the charge was given, what counsel said, and it wasn't you as one of your co-counsels, said we would rely on our reasons set forth in our motion in limine. So why is this standard of care judgment stuff preserved when that wasn't what was in the motion in limine or what was said in the charge conference?
Okay, so in the motion in limine, what we moved to exclude was not only evidence, but we moved to exclude jury instructions to the effect that a defendant was allowed a wide range of judgment. And we cited specifically the DeFranco against Klein case, the Rhode Island case, and that case deals with the error of judgment instruction. And the judge denied that motion after the evidence. And when the charge was read to the jury, Mr. Duggan specifically told the court that he wants to preserve the record on the instruction on page 10. And that is this specific instruction that is at issue and that the jury questioned, and the question of the doctor's judgment. And I think that's what Mass Rule of Civil Procedure, Rule 51, would require him to do, which is to object after that charge.
How would the judge know that your problems with part of the standard of care is the physician will use his or her judgment in accordance with accepted medical practice, when what you complained about was wide range, the judge never used, good faith judgment, and honest mistake, all things the judge didn't use? How would the judge know what your problem was with the instruction?
Because we objected to the instruction as given, or my counsel objected to the instruction as given. So that they objected to the specific instruction that the judge gave. And the motion in limine dealt with the question of jury instructions to the effect of this question of judgment. So, and the instruction itself is all about judgment. If we continue on, the second part of the instruction is the most problematic part of the instruction. And it says doctors are allowed a range in the reasonable exercise of professional judgment. They are not liable for mere errors of judgment, so long as that judgment does not does not represent a departure from the standard of care, resulting in a failure to do something that the standard of care requires, or in doing something that should not be done under the standard of care. In other words, a doctor is liable for errors of judgment only if those errors of judgment represent a departure of care. I would submit that the sentence, the paragraph doesn't really make sense. If you look at Webster's dictionary's definition of an error, it is an act or condition of ignorant or imprudent deviation from a code or behavior. So how can a physician commit an imprudent deviation from a code of behavior, which here is the standard of care, and still conform with it? By definition—
Counsel, this is all kind of in the abstract. Isn't it true that different kinds of medical decisions involve different ranges of judgment and discretion? If you want to take someone's temperature, there are particular ways you're going to need to do that. If it's more a decision of, do we do chemotherapy or not, there's a lot of judgment, and reasonable doctors may differ on those sorts of things.
Yes, and that is correct. Sometimes doctors are required to exercise judgment. Sometimes there are protocols in place that they're required to follow. But the issue is here, we are instructing a jury who 2 weeks before this instruction had never even heard of the standard of care. And so when we mix up all of these terms, when we mix up this objective standard of the standard of care, along with 7 times we tell them that the doctor can use his judgment, and then we add in this errors of judgment piece to it, I think it's unreasonable to think that a jury could even understand that. So it's not that we don't expect doctors to use discretion, just like we expect lawyers to use discretion in some instances. For example, I can suggest to my client that I think a settlement offer is reasonable. I can't just settle his case. I have to have his permission. So I think judgment plays into it and discretion plays into it from a practical perspective of the physician's practice of medicine, but it's not always pertinent to a jury instruction. And if you look at the Lacqua versus Silich case, that's a New York case that we cited in our reply brief. New York does give these instructions on a very limited basis. And if you look at that case, they said in that particular case, it's not a judgment case. It's a failure to diagnose cancer case. And what courts across the country say about this is, if you have a situation where you have had evidence of various types of alternative courses of treatment, then it's appropriate to talk about judgment.
Counselor, in this case, you haven't given us any of the evidence, any of the testimony by any of the experts. So how do we know this isn't one of those cases?
The issues at this case, and I don't think my brother in reciting the facts of this case disagreed with what we say. We had two sets of experts. One set of experts said, this is a medical emergency, you have to act very quickly. And Dr. KAPLAN, on the other hand, said, no, you have to go through these various steps. No one came in and said, here are 3 different alternatives and any one of them is fine. You can pick.
How are we supposed to know that? You haven't given that to us.
We have not given you that. We have given you the medical records. We have given you, my brother, I don't think has disputed this, except to say that judgment is always at issue in a case. What we know here is that the jury, well, let me take a step back too, because the closest case out there to this particular case is the case of the Grasses case. And that court dealt with a mistake of judgment instruction. And what Judge KAPLAN wrote is that the judge would have done better to spell out the point. But in the end, the court said, we think the jury understood it. We don't think that they thought that if the doctor acted in good faith, that the doctor wouldn't be liable. What we know here is regardless of any evidence at trial, the jury didn't understand this. They came back specifically and they said, they pointed to page 10, 3rd paragraph in the bottom and said, explain to us what this professional business means.
But counsel, the fact that the jury didn't understand it doesn't mean the instruction was an error. I mean, jurors come back all the time and say, I heard what you said about reasonable doubt. I don't understand it. And the same instruction gets given to them, whether they understand it or not. So
I would, in the criminal context, there are specific pattern instructions that are required to be given. That's not so in the civil context. And I would submit that the case law supports the idea that you have to give instructions to a jury that they can understand. And when they were confused, when they came back and said, we don't understand this, and our counsel suggested a remedy, he said,
counsel, isn't some of the confusion from the fact that these concepts are confusing in terms of how judgment relates to the standard of care and so forth?
Yes, these concepts are confusing, and that's why other courts have eliminated the use of judgment, and they've used other words. For example, in the Washington instruction on judgment, says a physician is not liable for selecting one or more alternative diagnoses if he's exercising in accordance with the standard of care. In Hawaii, they talk about there can be more than one method that can, and if it conforms to the standard of care, the doctor can choose. In Ohio, they talk about different methods in diagnosis or treatment. That is precisely my point, that the concepts are confusing. And so if we have an intersection of all of these concepts in a way that a jury could truly misunderstand, frankly, I think a lawyer could read this particular paragraph and not really get it. I think it's that confusing and that misleading and that mixing of concepts of subjective and objective. So yes, they are confusing concepts, and that's why we should be giving instructions that make that the least amount of confusion possible. I would also say that I went back. I haven't been able to find every edition of the MCLE instructions, but I do have an earlier edition, and I think it's around 2008, and that doesn't have any of this language in it. It doesn't have anything about errors of judgment. It does use the wide range of judgment, but then it says, if a physician utilizes his or her professional judgment, he or she is not negligent unless his or her judgment represents a departure from accepted medical practice and results in a failure to do something that acceptable medical practice obligates him or her to do, or causes him or her to do something the physician should not. Much easier to understand than this idea of errors of judgment, which in and of itself, I would suggest doesn't make sense.
Counsel, we have not so much time left, at a somewhat odd institutional question. What you're asking for us to do seems at least somewhat more appropriate for our colleagues on the second floor of the John Adams Courthouse than for us, in terms of coming up with, model instructions and such. To the extent that our primary role is error correction, aren't you asking us to do too much? Obviously, you need to ask us before you ask the second floor, but.
So to answer that question, we did also ask the SJC to hear this, and I submit that we did it too late, and they did not take it up. But we're not asking this court to create model instructions. There are no civil model instructions or pattern instructions in the Commonwealth of Massachusetts. But we think that this court certainly has the authority, just as with a Grasses court looking at the mistake of judgment, to say that this instruction, when viewed in a whole on judgment, is error, and it's reversible error, it's prejudicial error, because we know that 12 minutes after the jury was not given any explanation, they came back with a defense verdict. I don't think there's a more obvious situation where you could say that this instruction might have affected their thinking and the result.
Sorry to make you go over, but since we don't have the evidence, do you have anything else to show prejudice other than the jury question and the fact that they then rendered a verdict?
In the record, we have the motion. Obviously, we have the motion in limine. We have the transcript of the charge. We have the closing arguments of both sides that explain what they each believed the evidence to be. And then we have the jury charge and the question. We did not order the specific transcripts of the experts because we really felt like the problem itself was in this charge.
Okay. Any further questions from the panel? Seeing none, thank you very much, Attorney Cook. Attorney Kelly?
Good afternoon, members of the panel. May it please the court, Peter Kelly for the defendant appellee, Dr. Randy Kaplan. The jury instruction before the court on plaintiff's appeal was proper and in accordance with established precedent in Massachusetts. And we ask the court to affirm the judgment following trial that entered in favor of Dr. Kaplan. Contrary to plaintiff's assertion on appeal, the trial judge gave an instruction to the jury that followed the applicable law, and no basis is presented in this appeal to reverse and remand the case. There was no error of law and no confusion created by the court's instruction. Notably, as a threshold issue, and I believe that Justice Ditkoff raised this, Dr. Kaplan submits that the complaint now presented in this appeal is entirely distinct from what was presented at trial.
Well, Counselor, I don't know that you can say entirely. The motion in limine complains about wide range. The judge doesn't say wide range. The judge does say range.
Well,
I think that's enough to preserve an objection to the use of range.
what the plaintiff's brief raises is the phrase error of judgment. And there were 4 occasions that the plaintiff could have, prior to trial and at trial, raised that issue, and they failed to do so. The plaintiff's brief is clear that it is presenting in this appeal that phrase, error of judgment, that they consider inappropriate. And at pretrial, the plaintiff filed her motion in limine that addressed only the question of judgment. And it also indicated that there was an attached proposed instruction. And at no time was there a proposed instruction offered by the plaintiffs to the trial court. And that's at page 3 of volume 2 of the plaintiff's appendix, the motion in limine. The second occasion the plaintiff had to raise this issue was at the charge conference. And that's at the charge conference transcript pages 8, 9, 47, and 48. And counsel, in fact, thanked the judge when the court advised counsel that the model instruction would be used. This can be deemed acquiescence on the part of the plaintiffs, which is like the Jari versus Corsiro decision, a med mal case, where the plaintiff took no exception at the time to the proposed jury instruction. I'd also note for the court, so far as the plaintiff's effort to address the error of judgment now, rather than raising it at trial, that the Powers versus Soltesz case in 2014, decided by this appeals court, is analogous to this circumstance, where in that instance, the court found that the plaintiff had waived any argument as to a phrase second-year resident in the instruction. The plaintiff in that instance failed to object, as here the plaintiff failed to object to the error of judgment phrase. And the third occasion the plaintiff had to address this issue and failed to do so was after the jury charge, when under Rule 51, the court extended to the parties the opportunity to comment and raise objection and state for the record objection to the instructions. And the plaintiff at transcript page 122, again referred only to the motion in limine, and at no time raised any concern with the error of judgment instruction. The plaintiff had a fourth opportunity when the jury came back with a question during deliberation. And at that time, and this is at transcript pages 128 and 129, counsel expressed satisfaction with the judge's determination that a rereading of page 10 instruction on professional judgment would be given to the jury. So the plaintiff's failure to raise what it now asserts to be error, the plaintiff has waived that issue. And a defendant would submit it's not properly before the court. And also, defendant relies on the Flood versus Southland decision, again, as to the issue of what is necessary and required to preserve an objection as to an instruction. For those reasons, we ask that the court affirm the judgment entered in Dr. Kaplan's favor. Should
questions about the instruction, we'll take your waiver argument under advisement. Our colleagues in New Hampshire would tell us that the phrase mere the word mere and mere errors of judgment is a problem because it suggests that some negligence isn't actionable. Why isn't that right? Why isn't the word mere inappropriate?
Well, again, the purpose of the instruction is supplemental. And in professional negligence cases, it's important to instruct the jury, as with architect cases, engineer cases, attorney cases, to recognize that these professional activities require discretion, and that, particular to medical malpractice cases, that it's an inexact science, and the jury ought to be informed of those considerations when addressing standard of care. So to that extent, I think the characterization as a supplement, that there can be an error of judgment so long as there is adherence otherwise to the standard of care, is important to recognize the fallibility of professional conduct, even though in this instance, the physician follows the standard of care.
I'm sorry.
No, I was just going to ask, for me, a lot of the potential confusion comes down to the word error, because you could mean different things by an error in judgment. An error could mean something that didn't work and you should have done something else, or an error could mean you went outside the reasonable bounds of judgment. And shouldn't there perhaps be some clarification at a minimum of what is intended by this? Well, and I'm not saying in this case, I'm saying more generally.
Well, I think what we do see is that concern is recognized in these instructions, in that other courts that took exception to the phrase error of judgment were doing so under the circumstances that it was not tied back to standard of care. And in each and every instance in this set of instructions, to the extent there is recognition of there can be alternative, or there may be an unfortunate outcome, or there may be an error of judgment, that does not relieve the physician of liability unless the physician is acting within the standard of care. So as a standalone, I agree, it would be improper instruction. But in this instance in particular, and other types of instruction dealing with professional judgment, so long as it is tied to requirement that the physician adhere to the standard of care, it's proper supplementation and instruction to a jury.
Counselor, would you agree that sometimes there's a range of things a doctor can do, but sometimes there isn't? And do you think that, again, we don't have the testimony here, so maybe this isn't the case for it, but do you think that the range comment is something that belongs in some cases, but not other cases?
Well, I suppose it could be particular to a set of circumstances, yes. But consideration of this case, it was without question appropriate, with the decision Your Honor raised other parts of the testimony that are not part of the record. But this case did address throughout the case the question of judgment, in Dr. Kaplan's judgment, in his discretion in deciding the pathway of care for the patient. So there could be circumstances. This case was a case that required the instruction on range of judgment. If I may, to the extent the plaintiffs have identified other cases, and in particular, the Washington case. That case that plaintiff has submitted among their materials is the Fergan versus Sestero case. And at page 13 of that decision, in fact, that court in 2015 stated that the error in judgment instruction is a useful tool to remind juries of the fallibility of medicine. Plaintiff has represented that that is a case instructive in removing this instruction, but in fact, the case upholds error of judgment as a proper instruction. And I mention that only as counsel had raised it, the Washington case in her argument. If there are other questions, I would be pleased to answer. Otherwise, I would ask that the court affirm the judgment entered in Dr. Kaplan's favor.
Okay, Attorney Kelly, before that, I'm just going to check with the panel to see if they have additional questions or follow-up questions for you. And I don't see any, and I don't have any questions myself. Thank you very much for your argument. Thank you as well, Attorney Cook. We'll take the case under advisement and again answer back to the two of you as soon as we possibly can. In the meantime, on behalf of the panel, we wish you and your families good health and hope you stay safe in the upcoming months.